So today I want to talk about Kentucky Senate Bill 211. This is the bill that recently passed the Kentucky State Senate that would make it a criminal offense for anybody to insult a police officer. And while this is egregious enough in and of itself, and certainly worth talking about, there are other aspects of this bill that are also extremely problematic that I feel have gone largely ignored. So today I want to talk about the full extent of the bill and go over the bill itself and talk about its problematic aspects. In addition, I want to take some time to talk about the history of the bill, the reason behind it, as well as the potential future of this bill. Further, I want to talk about some quotes that have come up from Senator Danny Carroll, the Republican primary sponsor of the bill. So with that said, let's jump in and talk about the history of the bill. So Senate Bill 211 has come as a direct reaction and response to the racial justice protests, the BLM protests that occurred in Louisville and across the state of Kentucky last year. And I don't think it's a coincidence that the bill has advanced to the House of Representatives within a short framework and span of time from the anniversary of Breonna Taylor's murder, which of course was what sparked the demonstrations in the first place. And the reason for that is that the language that is codified within the bill seems to be a direct response to a lot of the demands and conversations in the BLM movement, as well as to the way that the BLM protests went. So with that said, what is the reasoning for addressing BLM in such a way? Well, Senator Danny Carroll is a Republican from Benton who was a former assistant police chief. So you have a former assistant police chief being the primary sponsor of a bill that is claiming that this bill is necessary to protect police officers. This is a police officer trying to protect police officers at the cost of the people of color who are often the victims of the police and who are considerably at risk for being attacked by said police officers, especially when we look at cases like Breonna Taylor's or George Floyd's, or so many more names that I could sit here and list off to you. Now, with that said, the bill passed in the Senate at a vote of 22-11. This included 6 Republicans who actually thought this bill went way too far. And I think that's worth talking about. There's a supermajority in both the Kentucky Senate and the Kentucky House of Republicans. And some Republican senators actually thought this bill went too far. And that's worth talking about. But the reason that Senator Danny Carroll has cited for this, again, is to protect police officers. He has said that we need to send a clear message to those outside of the Commonwealth that the welcome mat is no longer there if you plan to come to our Commonwealth to terrorize our people, attack our police, assault communities, assault people, assault first responders, and destroy our cities. Now, we need to backtrack for a second, because this perspective is one that is consistently used when there is a call out about the positions of people of color when they are upset, rightfully so, about the actions of the state and the police. There's this idea that comes out that these are outside agitators coming into the state, and it is meant as a dog whistle for white people to feel more comfortable that it is this idea of outsiders coming in, that it isn't the people within their own state that are having the problems. This is a consistent rhetoric and language that is used by Republican officials. And if you don't believe me, you can look it up yourself. There are numerous instances of this happening. And it is indefensible at this point. The idea that it would be quote-unquote outside agitators coming in and drumming up these protests. No, it has actively been the people in their own communities upset and outraged at the fact that police in their own communities have come out and been murdering them and assaulting them and treating them like second or third class citizens. This has been a consistent issue with the police departments. And again, this is a movement by this particular senator to try to make it sound like it's coming from outside when the problem is very much within the system itself. Furthermore, this same senator has said in these riots, which you'll note that he uses the language of riot as opposed to protest to differentiate it and to make it sound worse than it actually was. In these riots, you see people getting up in officers' faces, yelling in their ears, doing everything they can to provoke a violent response. I'm not saying the officers do that. They do. But there has to be a provision within that statute to allow officers to react to that, because that does nothing but incite those around that vicinity, and it furthers and escalates riotous behavior. So that is the reasoning behind why he wanted this bill to contain the language about insulting police officers. And this is just absolute bullshit. It just really is. First of all, what is the point of training a police officer? What is the point of having any sort of, police force that cannot respond to being insulted without violence? The protesters are meant to be meant to be peaceful, regardless of what the police do to them. That is the entire point of the protests, as a matter of fact. The police keep harming people on the streets and causing physical damage to people, and causing loss of life, and jailing people, and arresting people, and causing all sorts of violence against communities of color. And the response has been largely peaceful in that way. But when people get angry and something happens, and maybe a piece of property is damaged or someone gets injured, it automatically becomes the state and the police who control the monopoly of violence and say that it's okay for them to do whatever they want in response to that. So a bunch of people getting angry and insulting a police officer should be the least of the issues, and the police are the ones who are trained and paid to protect and serve, theoretically, the people, which they don't, which is why BLM has called for the defunding of the police. This is why this exists, because these institutions are consistently protected at the cost of people. So with that said, and having understood the reasoning that Senator Danny Carroll is sponsoring this bill and putting it out there to protect the police as a former assistant police chief, let's go over the language of the bill itself. So this bill is actively meant to be an act relating to public safety, and is something that is supposed to expound upon previous bills that have had ties to the Kentucky Penal Code, and they've added to it. So anything you see here that's bolded is actively in addition to the Kentucky Penal Code. So the first thing to note is that the bill specifically identifies fireworks. And fireworks means any composition or device for the purpose of producing a visible or an audible effect of combustion, deflagration, or detonation, including but not limited to bottle rockets, Roman candles, and firecrackers. So this is in direct response to the protests that occurred in Louisville and across Kentucky last year, because there were some instances in which protesters actively used what would be considered fireworks to intimidate or, otherwise as part of their protests. One time it accidentally or possibly purposefully hit a car and set it on fire. And so this is designed to specifically address that. Furthermore, the term riot was defined. And this is an extremely problematic definition of riot. Riot means a public disturbance involving an assemblage of 5 or more persons. Now, the reason that's already problematic is that 5 people is not a lot of people. You can imagine 5 people just walking together on the street, whether it be a family, whether it be a bunch of young people just hanging out with each other, or what have you. And that now can constitute a riot if a police officer decides to deem it as such. So who will primarily be targeted in a white supremacist system that has conveniently and historically attacked people of color? Probably any gathering of 5 people of color in the street could be now listed as a riot. Historically speaking, you usually use a number of about 12. I know Canada's statute uses 12, and I'm pretty sure British common law has defined a riot as 12 people. And that's generally what I have found as the standard for what number to use to define a riot. So 5 is an extremely low number, and is probably being designed to add more criminal offenses and make it easier for police to enact these policies. So it's 5 persons which, by the tumultuous and violent conduct, creates grave danger or of damage or injury to property or persons. And I'm sorry, the idea of injury to property is something that I cannot wrap my head around. You don't injure property. You can damage property, it can be destroyed, it can be harmed, but you don't injure it. It's not flesh. It doesn't cut and bleed and then regrow. It doesn't have to go to the hospital. We don't think of it in quite that way. And I know that's a legal term, but it's one that's always bothered me, so I thought it'd be worth mentioning. So injury to property or persons or substantially obstructs law enforcement or other government function. So even if 5 people just get in the way of any sort of law enforcement or prevent any aspect of government from functioning, they can be treated as a riot. And that gives the police so much leeway. So much leeway if this gets through. So moving on, one of the things that it also does is it defines that a person may use defensive force while in the middle of a riot. And what that essentially means is that if a person has any sort of reasonable fear that they are going to be harmed during what they have now deemed a riot, people can use defensive force at their leisure. So now any person who sees a group of people who they consider to be dangerous or threatening, 5 people, can now claim that if they decide to attack this group of people, that they are doing so as part of a defensive measure, and this should not be charged as part of a crime. Wow, that has the potential to be misused and abused by a good number of the people in the state of Kentucky, especially people who might be fearful of people of color because of racism or anything else. This is an extremely problematic aspect of the bill. Furthermore, there's another aspect of the bill that absolutely says that a person who's been charged with an offense during the course of a riot shall not be released until 48 hours have passed since the time of the arrest and the person appears before a judge. Which basically means you can't receive bail, you can't go home to your family, you can't get out of prison, you will be in prison for 48 hours. So what does that mean? Well, if you happen to be in a group of 5 or more people, and the cop decides to mess with you all, and decides to deem that you are in any way, shape, or form a riot, they can lock you up for 48 hours. And what happens if you're locked up for 48 hours? Chances are you're going to lose your job. If you don't show up for work for 2 days, you will probably lose your job. Especially if you have no way to contact. And then you have to appear before a judge immediately. And so you're not even granted any sort of ability to, go home, deal with your life, pay bail, defend yourself. Bail is completely denied here. Simply because you had a group of 5 people gathering, and the police officer decided to deem it a riot. That is an extensive amount of power that the police officer holds, because we are only trusting the police officer's claims on whether or not that's valid. Because as usual, we're only going to trust the police side of things. Moving on within this bill, they made it a crime to intentionally cause physical harm to a law enforcement officer or emergency service personnel by any means of chemical agents or fireworks. And again, it's hard to ignore that this is not in response directly to the BLM protests, given what I mentioned about the firework usage by protesters. And often it was the only means that they had. And there have been other protests across the country where certain chemical agents were used back against the police when the police abandoned some of their tear gas. And so while it has been used as a form of self-defense and protecting some of the protests, the police can now use that as a means to justify larger criminal charges against people. Furthermore, all of the perspectives of crimes that could be committed in this case, in what they are deeming a riot, can now be expanded upon. If, for example, A violation of subsection 1 of this is assault in the third degree is a Class B felony, or the violation of assault in the third degree is a Class B misdemeanor in a certain instance, committed during the course of a riot, it becomes a Class A misdemeanor. And there's other aspects of this that increase as well as assault with saliva, vomit, mucus, or blood during a riot would become a Class D felony when previously it was a Class A misdemeanor, which means the extent of this bill, when done by what is perceived as a riot, will increase in penalty. Moving on, we know that a person is guilty of assault in the fourth degree when, and it has prior reasons, but the bold part, which is the addition here, says he or she knowingly shines or aims a light, laser, or activated horn or other noise-making device towards the head of a law enforcement officer or emergency service personnel, with the intent to affect their ability to safely and adequately perform their duties. That means if you shine a light in their face, whether it be the camera on your phone, if you use a laser pointer, if you have an air horn, if you have a megaphone, if you have any of these devices on you, and the police officer happens to be nearby, they could even walk up to you as you're speaking. They could then deem it a crime, which would be considered assault in the fourth degree. And this is all extremely problematic. Now, furthermore, as used in this section, camping, they are defining camping. The reason they're defining camping is basically anyone between the time period of 10 p.m. and 7 a.m. who erects or maintains or leaves or allows to remain a piece of furniture, tent, raised tarp, or any other temporary shelter can be arrested. They are making it a crime to do this. And who will this affect primarily? Probably homeless people. Now, the bill does go out of its way to say no person shall be convicted of unlawful camping on property owned by the Commonwealth when he or she is a homeless individual, as defined in other parts of the law. But that doesn't mean that the police can't arrest people. In fact, they're probably encouraged to, because it's up to the judge to determine whether or not this person is homeless and whether or not it's lawful. So the cop can say, well, I didn't know, and still arrest the person. Now, this person has their property taken in by the police, and it's confiscated and maintained for up to 90 days. And if the person tries to go back to collect their stuff, they have to produce identification, which somebody who's homeless or poor might not have, and has to provide contact information and swear under oath that the property belongs to the person. Furthermore, the state can then charge a reasonable storage fee for said property, which means if a homeless person is being, targeted by the police and they decide to arrest the person under these statutes, it would basically become a issue where not only does the person get harassed and have to go to prison and have to deal with the judge, the person then has to provide identification that they may not have. And then, even if they can do that, they might have to pay a storage fee while they're homeless, essentially a tax on them to get their stuff back. And that doesn't mean the cops and police can't continue to harass them in the future. So this is a bill that is specifically targeting homeless people as well. Furthermore, resisting arrest is another one that can be moved to a Class D felony from a Class A misdemeanor. So it has now a felony to resist an arrest during a riot. Obstructing an emergency responder is now a Class D felony during a riot. Reminding people that a felony, if a person is charged with this, means that they no longer have the ability to vote. They no longer have access to owning a firearm in many instances. I don't know if Kentucky specifically is a state that does that, but I'm pretty sure it is. Most states have that type of policy on the books, and that means that it will be very difficult for them to get a job and the aftermath of this, assuming they didn't already just lose their job or have to pay legal fees in order to get through the process of them being arrested. So this is creating a lot of issues. especially when, again, this is specifically targeting people in response to the BLM protests. And we're seeing it written within the language. The idea that it's a riot, that it's fireworks, that it's insulting the police, that it's, the whole outside agitator thing that's come in. Because the idea is that someone who is an outside agitator being held for 2 days could also be an issue for them. That's kind of the proposal around things. So, furthermore, this is the part of the bill that everybody has been talking about. It is now a person is guilty of disorderly conduct in the second degree when in a public place with the intent to cause public inconvenience, annoyance, or alarm, or wantonly creating the risk thereof, he accosts, insults, taunts, or challenges a law enforcement officer with offensive or derisive words, or by gestures or other physical contact that would have a direct tendency to provoke a violent response from the perspective of a reasonable and prudent person. And who's the respectable, reasonable, prudent person who's going to get to make that call? A police officer. So they get to be judge and jury in this regard on whether or not this person has done something wrong against them. That's absolutely atrocious. Now, reasonably speaking, this part of the bill at the very least is not going to hold up in a court of law. Even if this passes the House, which it's likely to because the House also has a supermajority, even if the governor, who's a Democrat, I believe is a Democrat, decides to pass it into law and doesn't veto it, which it can get reversed because of the supermajority in the Senate and the House and that whole complicated mess. Even if it ends up in law, there's a chance the courts will probably shut this one down because this is a complete violation of the First Amendment. It is an obvious violation of the First Amendment, but that doesn't mean that it's not codifying something as an attempt. And the fact that a bunch of cops, a police chief, assistant police chief who's protecting the interest of cops, thought it was a good idea to introduce this into law, and that a number of senators backed it up, that is scary. That is frightening. The fact that enough people thought that an authoritarian measure that denies true free speech, the ability to protest and come out, both in the form of, what they're declaring as a riot, and furthermore, to come out and say that it's illegal to insult a police officer is egregious and is something scary and worth talking about. And Kentucky, just like a lot of the other parts of the South, needs to get their states, senates, and houses in order. Because at this point, it is very obvious, at the very least, these states, if not more of the country, has a huge racism issue and is effectively an occupied territory when it comes to the rights of people of color. Furthermore, moving through other aspects of this bill, I know it's a lot, but this is one of the ways that we firmly know that this is in response to the BLM protest. The General Assembly, in Section 16, the General Assembly of the Commonwealth of Kentucky hereby finds and declares that 1. Adequate and substantial investment in law enforcement is essential to protect and promote the quality of life of all citizens in the Commonwealth. We effectively know this isn't true because it's not all citizens, and it's not even all people that benefit. But it is a certain class of people that benefit, and they know who they're talking to. 2. Governmental entities responsible for funding the various law enforcement agencies shall maintain and improve their respective financial support to the Commonwealth's law enforcement agencies. And 3. The General Assembly expressly reserves the right to enact future legislation that would implement specific procedural requirements to ensure adequate funding and support of law enforcement agencies. This is basically a slap in the face at the idea of defund the police. All of this is saying police aren't necessary, they should not be defunded, they should not be abolished, they should exist, they need to exist, they are important in their communities, and we reserve the right to fund them as much as we damn please. Really? Because that's necessary, because they don't already have the right to allocate resources and funding as part of the Senate. They had to codify this into law. And the fact that they felt the need to do this is a slap in the face. It is a direct attack on the ideas that BLM was putting out there. You mix that with the language of riots in response to protests, the outside agitator comments, the fireworks stuff, and it really reads as a very obvious response to BLM, and it's racist. It is extremely racist. And this part of the bill may not be something that is able to be taken down by the court of law. I'm not a lawyer. I'm not a legal expert. I'm not 100% sure. But I'm not sure this violates anything by simply stating it. But it's letting the police know exactly where the state senate lies and what their role is in all this. And even if this bill ends up failing, even if this bill ends up not being passed, it is sending a distinct and clear message to the police departments. This is what we support as a state. This is what we want. And I think more than anything, it also sends a direct message to the communities of color that flat out says, you think you're going to go out and protest and do all the things that you did before last year? We don't think so. We are going to make it hell for you to do so. We are going to literally criminalize your efforts to try to stand up for your rights, to stand up for the people that we murder as police, and make it literally a crime to protest and stand up for those issues. This is an egregious piece of legislation, and I hope it gets torn apart in the courts. I actually hope it doesn't even get signed into law. But again, the fact that a bunch of senators thought it was enough to pass, that it was worthwhile to pass this, and that it was good, in addition to all of the other bills that we've seen that are suppressing voting rights, and bills that might be similar to this across the country that are going to start popping up and have started popping up. This is a conversation we really need to talk about, because this is going to hurt people. People are going to die and lose their lives over this. And we need to stop this. So with that said, if you like this video, give it a thumbs up, hit the subscribe button and bell for notifications. You can follow me on Discord and check out my Twitter in the description down below. My name is Anarchist Tara, and I hope you enjoyed watching.